Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about the definition of abuse for the purposes of Illinois Orders of Protection. We're doing a whole series on orders of protection, and probably a good place to start is our video and article, Illinois Orders of Protection Explained, at our website, learn-about-law.com. That gives a broad overview of all of the legal issues you need to understand regarding orders of protection. Today and in some of the subsequent videos we're honing in on particular issues and giving more detailed explanations. And like I said, we're doing a series of these, and it's pretty comprehensive. So hopefully by the end of these videos, you'll know everything that you need to know about Illinois Orders of Protection. So first of all, let's talk about what an order of protection is. An order of protection is an order from a court issued for the purpose of protecting the petitioner or another protected party that the petitioner is filing on behalf of from abuse at the hands of a family member or household member. We should note that the definition of family member or household member is very broad. It includes previous dating relationships, previous living situations. It's a broad definition. We talk about that in our previous video, Illinois Orders of Protection Explained. The definition of abuse is also very broad, and that's what we're going to delve into. The definition of abuse is important because previous abuse by the respondent to the petition, the person who you're trying to get protection from when you file the petition for order of protection, previous abuse from that respondent is a prerequisite for getting an order of protection. But again, the definition is broad. It includes threats, it includes harassment, and we're going to go over the definition of abuse right now. So abuse is divided into 5 basic categories, and we'll discuss each of these in detail. The first is physical abuse. The second is harassment. The third is interference with personal liberty. The fourth is intimidation of a dependent. And the fifth is willful deprivation. If you're not sure what intimidation of a dependent or willful deprivation might be, don't worry. Those are terms of art, and we'll explain what they mean as we go on here. First, let's talk about what constitutes physical abuse for the purpose of Illinois Orders of Protection. A lot of different behaviors can constitute physical abuse, and they're not all what you would necessarily think. First is knowing or reckless use of physical force, confinement, or restraint. So it doesn't have to be intentional force. It can be reckless use of force. Knowing, repeated, and unnecessary sleep deprivation. Knowing or reckless conduct creating an immediate risk of physical harm. So the harm doesn't have to have occurred. It has to be knowing or reckless conduct that creates a risk of physical harm. Threatening with a weapon or forcing someone to have unwanted sexual relations. So that's what physical abuse is. And that's going to be important later because some of the other definitions rely on the definition of physical abuse. So let's next talk about what constitutes harassment for the purposes of orders of protection. Harassment is any behavior that meets all of the following 3 criteria, and they've all got to be true in order for it to be harassment. 1 is intentional conduct, which is not necessary to accomplish a reasonable purpose under the circumstances. 2, that would cause a reasonable person to suffer emotional distress. And 3, the conduct did in fact cause the person to suffer emotional distress. So it's basically intentional, unreasonable conduct that would cause a reasonable person emotional distress and in fact caused emotional distress. Now, this is a lot of gray area as to what this type of behavior would be, and there can be a dispute in court about what would cause a reasonable person emotional distress, what is unreasonable conduct. But certain types of conduct are presumed to cause emotional distress, and that simplifies the process. And we'll go through that conduct now. Creating a disturbance at the protected party's workplace or school, repeatedly calling the protected party's workplace or home, repeatedly following the protected party in public, repeatedly remaining outside the protected party's home, school, workplace, or any other location that the protected party is occupying, repeatedly peering into the protected party's windows, improperly concealing the protected party's minor child, or repeatedly threatening to remove or conceal the minor child from the jurisdiction or from the petitioner's care. It doesn't have to be repeated. It can be a single occurrence if the respondent has actually attempted to do this in the past. And finally, repeatedly threatening physical force, confinement, or restraint. So those are the types of behaviors that are presumed to cause emotional distress. Now, there's some other behaviors that in the past, according to case law, have been found to have caused emotional distress. They don't necessarily automatically raise the presumption, but they're likely to be found to cause emotional distress because other cases have found them to cause that. Those are things like yelling, calling names, using angry expressions, breaking or throwing the protected party's property, humiliating the protected party, accusing the protected party of infidelity, constant telephone calls or letters, and threats of suicide. So all of those things are types of behaviors that have been found to be harassment. And again, harassment comes down to that three-pronged definition: unreasonable intentional conduct that is likely to cause emotional distress that does in fact cause emotional distress. There are some behaviors that we've discussed that are presumed to cause emotional distress, and that last set of behaviors have been found, they're not necessarily presumed, but they've been found to cause emotional distress and thus lead to harassment. Let's next talk about interference with personal liberty. And these next couple definitions, subcategories of abuse, have very specific definitions that I'm just going to read to you because they're terms of art, and we'll unpack them a little bit. But interference with personal liberty for the purpose of orders of protection is defined as committing or threatening physical abuse, harassment, intimidation, or willful deprivation so as to compel another to engage in conduct from which he or she has a right to abstain, or refrain from conduct in which he or she has a right to engage. So let's unpack that. It's basically doing something wrongful, and that can be physical abuse, intimidation, or willful deprivation, which we'll define later. Doing something wrongful to manipulate the behavior of the protected party, so to make them do something that they otherwise wouldn't do, or refrain from doing something that they otherwise would do. So some examples of things that have been found to be interference with personal liberty: behavior that would tend to isolate the petitioner from family and friends, restraining the petitioner through physical force or manipulation, or controlling the petitioner's movements by monitoring them. So those are the basic idea. Is this can be manipulation, it can be surveillance, it can be all sorts of types of behavior that wrongfully restrain the actions of the protected party. The next subcategory of abuse that we're going to talk about is intimidation of a dependent. And this occurs when a respondent subjects an individual who is a dependent because of age, health, or disability to participation in or witnessing physical force against another, or physical confinement or restraint of another, which constitutes physical abuse as we defined earlier. So basically, this goes kind of hand in hand with physical abuse, but it's requiring basically forcing a minor or some other dependent to watch you do something that would qualify as physical abuse or restraint to someone else, or having them participate in that, and that constitutes abuse within the definition of the law. Finally, we'll talk about willful deprivation, which is the last subcategory of abuse we'll discuss. This is basically the bottom line of willful deprivation isn't actively doing something to somebody, but denying them something they need when you have an obligation to provide it. So willful deprivation occurs when a protected party requires medication, medical care, shelter, food, a therapeutic device, or other physical assistance due to age, health, or disability, and the respondent willfully denies the protected party such necessities, exposing the protected party to harm. So there's no affirmative duty that's created by the statute in this case. It's someone who already has the duty to provide these things. So if you've undertaken to have a family member live with you and you're going to take care of them, then you now have the duty to take care of them. If there was no pre-existing duty, there can't be willful deprivation. So this is, caretakers qualify as household members. This is typically done with personal assistants, caretakers, or family members that live with you that have undertaken to care for you, and they intentionally and willfully choose not to provide you the care that you need. The harm that is an element of willful deprivation can be physical, mental, or emotional. So it doesn't have to be physical harm. Willful deprivation does not occur when the protected party is intentionally foregoing the care that they need. So if they're choosing to be deprived of the care, you can't get an order of protection for willful deprivation for someone who's going along with their wishes. So again, to kind of sum up, abuse is a really broad category, and again, it's important because abuse is necessary to show in order to receive an order of protection against a family or household member, another broad category. But the 5 categories of abuse are physical abuse, harassment, interference with personal liberty, intimidation of a dependent, and willful deprivation. And they're all different flavors, and they're all terms of art. We've gone over a lot today. We have an article at learn-about-law.com that kind of bullet points all of this. So if you want to pick this apart in more detail, check that out. And again, I'd encourage you to check out the kind of mothership of this series we're doing, which is Illinois Orders of Protection Explained, and some of the other supplementary videos we're doing to explain orders of protection. Thanks so much for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.